Well, the Trump administration scored a legal victory after a federal appeals court allowed them to move forward with the plan to deploy National Guard troops in Oregon.
Local leaders, though, say they will do whatever they can to stop that deployment. Fox's Connor Hansen has the details.
After getting blocked twice by a federal judge's order, an appeals court has cleared the way for President Trump to send troops into Portland, Oregon. The city has seen constant clashes between federal law enforcement and protesters. The administration argues National Guard troops are needed to help protect them.
They're out burning courthouses in Portland. We are treating them as terrorists, just like we do Al-Qaeda or ISIS.
Those National Guardsmen will likely be stationed at a Portland ICE office. But local leaders have repeatedly said troops are not wanted or needed.
The vibes are definitely feeling a lot of confusion and wondering if this is what they signed up for.
I've been very clear, especially when I met with Secretary of Homeland Security, Secretary Noem, that the use of the crowd control techniques from federal agents was over the top.
Meanwhile, the White House has made an emergency appeal to the Supreme Court in its attempt to use troops in Illinois. There have been regular protests outside an ICE facility there, but court decisions have been hinging on how violent demonstrations become. So far, lower courts have blocked it.
It's clear that the administration is trying to provoke, trying to create scenes of violence that will empower them or enable them.
The court has yet to rule if troops from around the country can be federalized and sent to Portland, or if they can only include members of the Oregon National Guard. In New York, Connor Hansen, Fox News.
All right, for more, we're joined now by Laurie Levinson, law professor at Loyola Marymount University. Professor, always good to see you, and we appreciate the time. Let's start first, if we could, with this ruling by a three-judge panel of the Ninth Circuit Court of Appeals when it comes to deployments in Portland. They essentially said that it appeared the president had broad authority to take over and federalize the National Guard in that state and deploy them. What are the implications of this ruling for the broader question in this country about how much authority the president has to send National Guard troops into American cities?
Well, this decision was actually a split decision. You had two Trump appointees who said that there should be great deference to the president. And if he thinks there's a need for the National Guard, he should be able to call them out. And that when they look at what rebellion is, it's anytime people are pushing back, and they were willing to look at facts way back to what was the situation in June, which was much more volatile than it is now. Now, the trial judge in this case didn't see the facts this way, and the dissenting judge says this is absurd. Just have a handful of protesters who are outside of ICE in Portland, and some of them are wearing chicken suits or no clothes at all. So how does this become a rebellion? But to answer your question, because we have a split in decisions. In Chicago, we have the appellate court saying no, the National Guard cannot be called out. Now, in Oregon, you have the appellate court saying they can be. This is going to have to go to a higher court. And initially, it might go to the full Ninth Circuit, but I do think it's headed to the Supreme Court.
And speaking of the U.S. Supreme Court, as was mentioned just a moment ago, on the issue of National Guard deployments in the Chicago area, the Trump administration has filed that emergency appeal to the U.S. Supreme Court. And in that filing, one of the things that stands out to many people is what they told the justices. They said, if the president's determination is reviewable at all, such review must be extremely deferential. How do you think the administration is going to make the case that the courts, in their view, really have no role in questioning a decision that a president makes to deploy troops to U.S. cities?
Well, one of the judges in this Ninth Circuit case took that position. Basically said it's up to the president under the statute to make those determinations of whether it's rebellion. But the other judges didn't go that direction. He said there has to be some review. The judge doesn't have no role in this at all. And the president, even if you're deferential, has to stick to the facts on the ground. So I do think the Supreme Court ultimately has to define for us what's a rebellion. Is it anytime people are exercising their constitutional rights and protesting? Does it go that far? If so, there's not many rights left. So the Supreme Court's going to have to decide, how do you look at these protests? Are they rebellions or are they protests?
All right, so how quickly do we expect a ruling on this emergency appeal? This is obviously centered on the situation in Chicago, but it obviously has broad implications for cities across the country. How quickly do you think the High Court is going to move?
Well, we actually don't know. It's a bit surprising they haven't moved already. This was filed on Friday. It's an emergency. They could have issued an order at any time. But I do think now that they're looking at this case, they realize it's beyond this case. They can't look at the Chicago case without having the Oregon case in mind and perhaps California and all around. So ultimately, they've got to take this case. And it's a bit dicey taking it on an emergency basis because we're still going to have a trial up in Oregon about what the facts actually are on the ground. And perhaps the Supreme Court wants to know that as well as what the lawyers are saying in the papers.
How is the Supreme Court taking this up on an emergency basis? How will the case unfold differently than if they were to take it under different circumstances?
Well, by an emergency basis, they have a limited record. They just have what was filed under the emergency temporary restraining order. You don't have a full trial. Can't really assess credibility of witnesses, sort of making your knee-jerk reaction to what's going on. So that has been one of the criticisms of the Supreme Court, ruling so frequently on these emergency appeals because they're not fully developed and they're not fully briefed and they're not fully argued.
All right, but we do expect the High Court probably will be moving quickly here to issue a ruling in the Chicago case, and it will have implications across the country. We appreciate the insight. Always great to have you on. That's Laurie Levinson from Loyola Marymount University. Good to see you.
See you.
Thank you.